All right. Hello. Thank you so much for joining us today for our Wednesday webinar. Today, we're going to be talking about Social Security disability insurance claims and how age 55 and up can impact those claims. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm where we provide Social Security disability representation throughout the country with compassion and experience. And of course, this webinar, as all of our webinars are, will be recorded for future reference. It'll be posted to our YouTube channel. So if you are watching this on the replay, welcome and thank you so much for joining. Always takes me a minute to figure out how to get it going. A little bit about Beacon Disability. We do work exclusively on disability claims nationwide. We've got over 10 years of helping clients win the benefits that they deserve directly with the Social Security Administration. And we focus on a client-centered approach where we have compassionate representation through every step of the claim, from the initial application to the reconsideration stage to the hearing stage through the appeals council. We do not currently handle federal appeal cases. We only handle Social Security disability claims at the agency, which is the initial application all the way through to the appeals council. We also do offer free consultations, so you can give us a call directly. You can visit our website. Below, if you're watching on the replay, below we will have a link where you can schedule a call. And then if you are on the live webinar with us, that link has been dropped into the chat as well. So please do feel free to give us a call if you have questions, if you're thinking about applying for disability, you have applied for disability. And of course, today we're talking about the grid rules for individuals over age 55. And so if you fall into that category and have questions about the grid rules, how they may apply to your case, feel free to give us a call. We are always happy to chat. So understanding eligibility for SSDI benefits. So there are two different programs for Social Security disability benefits. There's SSDI and then there's SSI. SSDI, Social Security Disability Insurance, are benefits that are based on what you were able to pay into the system while you were able to work. They usually require that you have worked 5 of the last 10 years. If you are a young individual in your 20s, maybe even early 30s, the rules change slightly as far as how much of a work history you have to have. But as we're talking about individuals ages 55 and up today, for individuals age 55 and up, you do have to have worked and paid into Social Security for 5 of the last 10 years to be eligible for SSDI benefits. If you had worked previously and don't have that 5 of the last 10-year requirement, you may still qualify if you can prove that your disability started on or before a certain date. And as far as paying into Social Security on an annual basis, the amount required varies, but it might be lower than you think it might be. So if you've worked even part-time for 5 of the last 10 years and you think that that may qualify, you can certainly feel free to reach out to us. The other thing that you can do, and might be better to do, is actually to log into your My Social Security account. In there, you'll be able to you'll be able to see what Social Security is showing your earnings history as, so that way you would know if you may or may not qualify for SSDI benefits. SSI does not have a work history requirement. Instead, you have to have minimal income and resources. So minimal income, assets, things like that. Both programs are going to require that you have a medically determinable impairment that results in the inability to perform substantial gainful activity for a period of at least 12 months. Now, you do not have to be disabled and unable to work for 12 months before you even start applying, but that has to be likely. So when you initially apply, if it is likely that you're only going to be out of work for 6 months, Social Security is likely going to deny that claim, and they may say, we think that you're going to be better within a year. So those are kind of the requirements of Social Security disability eligibility. SSDI and SSI have their own requirements as far as work history or income and assets go. And then both programs are going to require that you have a severe medically determinable impairment that prevents you from engaging in any type of substantial gainful activity, and that has lasted or is expected to last at least 12 months. So as you can see, the guidelines for qualifying for disability are relatively strict, and medical evidence is critical to establishing your claim and proving your disability to the Social Security Administration. They cannot just take your word for it that your knees are bothering you. They do need to see that medical evidence that backs it up. They can't take your word for it that your back makes it so that you can only stand for 5 minutes at a time. They do need to see the medical evidence that backs that up. Both of those things might have imaging that goes along with it. Of course, there are other conditions that don't have supporting imaging, but all medical conditions should have some type of medical record that can be obtained that can kind of help to lay that groundwork to show Social Security what your impairments are, what limitations those impairments leave you with, and then again, that they are either have lasted or are expected to last at least 12 months. So the medical vocational guidelines, also known as the grid rules, it's basically a chart that you can find. It's used by the Social Security Administration to determine eligibility for disability based on certain factors. So they divide it up by age, residual functional capacity, and then within that, they also look at your education and your past work experience and whether you have any transferable skills from that past work experience that can transfer to other jobs. So in that vein, age thresholds matter. When looking at those grid rules, you'll see that there's classifications as a younger individual, which is individuals under age 50. Then there's closely approaching advanced age, which is 50 to 54. And then there's advanced age, which is 55 to 60, or 55 to 59. At 60 could be closely approaching retirement age in some of the grids. So that is kind of the crux of the grid rules. They first look at your age, they classify by age, and then they classify by residual functional capacity, which is usually defined as sedentary, light, medium, heavy. The lower the residual functional capacity, the easier it is to qualify under the grid rules. And the older an individual is, the easier it is to qualify under the grid rules. So that's why it's saying there that the rules become more favorable at 50, and then again at 55, and then again at 60. So age 55 is a critical threshold. Social Security classifies that as advanced age. At that point, the grid rules become a little bit more lenient than they were at 50 to 54, which results in a higher success and increased approval rates for applicants, and because of the easier approvals. There are lower expectations for the ability to adapt to different work. So that's where transferability of skills from former jobs come into play, especially if you are making a shift from previously doing medium or light work to now, because of physical impairments, you're limited to sedentary or less than sedentary work. So age 55 is a pretty critical threshold within the Social Security Administration's disability evaluation process. Age also has an impact on past work analysis. As I mentioned before, there are somewhat reduced expectations. The Social Security Administration acknowledges that there's a greater difficulty returning to previous employment or new employment once you hit 55. And so they're going to look at what kind of tools are required, what kind of transferable skills you may have gained from that. And sometimes you can still go back to do your past work or other work based on transferable skills, but the administration does set the grid rules up in such a way that they do understand that there is a little bit of a greater difficulty in getting into the workforce at 55 and over. When looking at your work history, the agency is looking at the past job's physical demands as compared to what your current limitations are and what you're currently able to do as a result of your impairments. And so age-related physical changes do factor into the assessment of the ability to perform past work. So as I kind of mentioned before, skill transferability is one of the things that the agency is looking at when they are using the grid rules. They are looking to see, do you have skills from your past work that can be used to transfer to other skills? If you've watched some of our webinars before, you may have heard me talk about nurses as an example. So oftentimes we'll have like an OR nurse, and nursing is a skilled profession. And so these skills that that nurse learned in the OR or even on the floor of a hospital may be transferable to other work that is not quite as demanding, like work as a school nurse. That's one example that I've heard given as far as skill transferability. You're still using that medical background, might be a transferable skill, but you're not still helping to operate on a patient. You're not still helping to move patients, that may weigh 250 pounds or more. So it's a little bit of a lesser physical demand, but still has those skills that you've gained and used during your career as a floor nurse or an OR nurse. The grid rules are also meant to help recognize that as we get older, there's a little bit of a difficulty in being able to master new job skills. And so that also comes into play when they're looking at the grid rules and whether or not you can adjust to other types of work. Kind of along those lines, the agency considers the feasibility of workplace adaptation, and disability may be able to be found using the grid rules if adjustment isn't reasonable, or if they think that it's not something that you would be able to do. You don't have transferable skills from your past work to other work that you would be capable of doing. Some of the common challenges for claimants ages 55 and up: just because you hit 55 doesn't mean that you're automatically guaranteed a disability approval. You do still have to have medical documentation that supports your claim. Proving the functional limitations that you have can be difficult without comprehensive medical records. And so by treating and by keeping track of who you're treating with, Social Security can help you get those records. If it's easy enough for you to request those detailed notes, I usually recommend that clients do that. It helps you to keep track of what you've got as far as your medical records go. You'll have them. Don't send the only copy you have to Social Security.